Hi, everyone. My name is Kelsey Affronte. I am an attorney at Beresford Booth in both the litigation and family law groups. And today we're going to be talking about a question that I get a lot, which is writing declarations for court. Where do you start? What do you do? What is important? All are good questions to ask. And so we're going to kind of walk through my tips and tricks about getting your voice and your evidence before the court when you're writing your declaration. So, what is a declaration? A declaration is your written testimony, and it is testimony because at the end of your declaration, you are signing under the penalty of perjury that the information in your declaration is true and correct. So, that's why it's really important to understand that it does constitute testimony. But it's also, your story in your own words. It is likely the first time that the court is hearing directly from you and getting to know you and how you ended up on a judge's desk. So, it's an exciting opportunity to put your true voice before the court. A declaration also includes exhibits, which are corroborating evidence. So things that confirm that what you are saying is true. For example, on X date, so and so text me, blah, blah, blah. Okay, well, let's include a copy of that text message so that we're improving your credibility and showing the court that what you are saying is more likely to be true than not. And then when is a declaration used? So a declaration is typically used to support or oppose a motion in litigation. And so that's why this webinar does not only apply to family law or it applies to all types of litigation. So if you are filing a motion for summary judgment in a civil case, if you are filing a petition for a protection order, if you are in divorce proceedings, all of those things have opportunities for you to file a declaration of your testimony and get your evidence before the court. It is important to understand, though, that just because you draft a declaration in your case does not mean that then you don't have to testify later. So if your case goes to trial, your declaration is not admissible in lieu of live testimony. And that's a question I get a lot, especially not even just from clients, but from third-party witnesses. Well, I wrote a statement, so why do I have to come to court? Well, it's just not how it works. And there are a lot of reasons for that really aren't relevant to this, but it is important for you to understand that just because you said it once doesn't mean you won't have to say it again. And what's important to know about that is that your declaration can be used to impeach you later during your live testimony if you testify inconsistently with something that you previously testified to. So it's really important to confirm that what is in your declaration is true. And also important to review your declarations before you testify, either in a deposition or in trial, so that you can remember what it is that you said exactly, to try to avoid some of these credibility issues later. So then the question is, you're sitting down, you're getting ready to draft. What do you need to know before you start drafting? The first thing is that a lot of superior courts have page limits. So King County, Snohomish County, they both have page limits, especially in family law proceedings, as to the number of pages that your declaration and exhibits can include. So you need to know, okay, what is most important to include in that page limit? The other thing that you want to consider that, really is more for your attorney to consider, but something to keep in mind is that there might be evidence rules that preclude bits of testimony. So in protection order actions, the evidence rules are extremely relaxed. Hearsay is not an issue. And hearsay is a statement that is an out-of-court statement that's being offered for the truth of the matter asserted. So if you're saying, so-and-so told me X, that is potentially hearsay unless it falls under an exception. So that's particularly important because that's how a lot of us get information. Somebody told me this, so I did Y. And so if it's not a hearsay exception and it would be precluded by the rules of evidence, Well, then your attorney probably needs the contact information for the person who told you that, even if it is a two-sentence declaration saying, I told so and so on X date, the thing that they're saying I told them. Well, now you've avoided this hearsay issue, but it also goes back to the page limit issue. So you really have to evaluate what is, highest priority for your motion or your matter. And then you want to know, what is your motion about? What is your requested relief? What are you asking the court to do? Because that should really determine what it is that will be relevant for the court to consider in deciding whether or not to grant your requested relief. And then we talked a little bit about this, but what evidence do you have to support or corroborate the statements that are in your declaration? So you want to be thinking, do I have text messages, emails, photos, security footage, maps, surveys, all of these things that can be attached to your declaration that, again, corroborate and increase your credibility, showing that what you are saying is true. So these are things that you should be considering before you're drafting. So then where do you start? And I like to start with who, what, where, when, and why. So the first thing that you should say is who you are and who the other party is. Who are you in the case? Are you the petitioner, plaintiff, defendant, respondent? Who is the other party? Is it your soon-to-be ex-spouse? Is it your contractor? Is it, an employee? You're going to want to identify for the court who the key players are that you're going to be talking about in your declaration. And that should really be the first thing that you do, so the court is oriented as to why these people or what you're about to say is important. The next thing is the what and the why. So you need to explain to the court why you are asking the court to grant your relief. So a clear statement at the beginning with an intro. I am asking the court to do X because Y. So I included an example here just for ease of understanding what I mean, which is I'm asking the court for a domestic violence protection order because on April 12th, 2025, my husband assaulted me when he shoved me. Okay, you've now told the court what you're asking the court to do. You're telling the court that domestic violence was committed against you by an intimate partner, and you've established the date. So you've already packed in a lot of relevant information just by telling the court what it is you want the court to do and why. And then the last thing that will start your declaration is when. Start with the most recent relevant event and then work your way from the beginning to that most recent relevant event. So for example, typically in a protection order matter, there are several examples of domestic violence. I want to know why you're just now asking the court for a protection order if you've been enduring years of abuse, right? So what was that most recent incident that kind of flipped that switch in your head that made you realize you need this protection? Or in a motion for temporary family law orders, what is the most recent relevant event? Well, it's probably on X date. I filed this petition. I'm asking the court to enter temporary family law orders, including a parenting plan, child support order, etc. And so you'll want to start with, I moved out of the house on this date, and then probably work your way from beginning to end as to what's important. So, for example, your employment history, their employment history, your kids' history, your involvement in your kids' lives, things like that. So who, what, where, when, and why is a very good place to start. And if you haven't answered those questions, then your declaration is missing something. So now you're sitting down to draft. I always say over include, or as I tell my clients, word vomit. Just get it all on a page, because I don't know what you don't tell me. And also you will figure out what is relevant and important as you're drafting this, right? So the easiest place to start is to just put it on a page. Over include, really just tell your story and get it on paper. So if you're not sure if it's relevant, include it now and you can remove it later, right? So that's a determination for you and your attorney to make. So include it now just in case, because again, we don't know what you don't tell us. And remember that declarations are a process. Your first draft is never going to be your final draft. That is not going to be what is submitted to the court. So that's why it's important to just start somewhere, get it on paper. And as you're going, be thinking about, what is my supporting evidence? Do I need to check my text messages? Do I need to review my emails? And kind of keep a list of where you think you have these pieces of corroborating evidence. And compile them, get them ready. I mentioned this in paragraph blah, paragraph blah, paragraph blah, so that your attorney is also oriented to what it is you're talking about when they get a copy of your declaration and these exhibits. Again, as I've said multiple times now, attorneys don't know what you don't tell us. And so you should not try to paint yourself in the best light possible. We need you to tell us the bad facts too. And the best thing about that is that we, by law, are required to be your secret keeper, absent some exceptions. And so it's important to tell us the bad facts so that we can evaluate, okay, do we get ahead of it now? Do we have a strategy for when it comes up later? Because trust us, it will come up. So it is important for us to know so that we can operate with those bad facts instead of being surprised by it later and potentially damaging your case overall. So again, your first draft should be over-inclusive. Keep a list of things you think might be supporting evidence, and don't leave out bad facts. So your second draft, this is where you're going to start deleting. And what I always say, actually, going back to the first draft, is I really like to recommend to my clients that the first thing that they do, either at the time that we're doing a consultation or at the time I'm being retained, is do exactly what I did. What I just said, word vomit on paper, tell me everything from your perspective, and this will kind of become our living document, right? So while it might not be relevant now, it might be relevant later. And so instead of us having to duplicate work and racking up fees by having multiple phone calls about the same thing, if you have it in this document, then I can look at that. And that's kind of your living document. So it's your word vomit narrative. So I know from your perspective, how things have been going. Your second draft, and this is why I bring that back up, is don't delete your first draft. Save it somewhere. This should be your second draft, a new version, right? Read it from top to bottom, all the way through. I recommend reading it out loud. You can also have Word read it out loud to you, and start to organize. Add signposts. So like I was mentioning earlier, your employment history, your ex-spouse's employment history, your involvement in the kids' lives, or in a motion for summary judgment, this section relates to my timber trespass claim. This section relates to my waste claim, so that the court is oriented about where you're about to take them, that you have now moved from one topic to another. And it will help create organization, but it will also help keep you on task, right? Does that go in this section? Is it relevant to this section? And that bleeds into the next question. Ask yourself, is that relevant? Is it necessary for the court to know? Does it make your own statement or another statement more or less likely than it would be without it, right? So does it make that fact more likely or less likely if you include that statement? And that can include kind of attacking what you anticipate the opposing party is going to say, right? So I need to include this to get ahead of it because I know that bad fact is going to come up when they respond. So it's relevant for that purpose. Does the court need to know it right now? Right? Because while you may feel that something unjust happened to you and it's unfair and you want to tell the court about it because it's unfair and it's unjust, well, does it go to your ultimate request right now? The answer might be no. And so in order to keep the court focused on what they need to know in order to grant your request and keeping in mind page limits, I'm probably going to tell you, I understand that's frustrating and why you feel it's important for the court to know, but we need to stay on task because if not, it detracts from your credibility, right? I already talked about this. Should you control the narrative about the bad fact? And then is your statement supported by other pieces of evidence? If it is not relevant to your current motion, delete it. Okay. And err on, the side of caution. At this point, I would say, don't delete it if you have a question about it. Leave it highlighted, ask your attorney. But when you're doing stream of consciousness, you're talking about your thoughts, your feelings, your intent, what you thought somebody else's intent was, things like that, that might not be relevant to the court right now. And so you kind of need to get rid of that and get rid of that language. And that's why I say, don't delete your first draft, start a new draft. So then once you've read it from top to bottom and you've kind of struck out sections that you don't think are relevant, you're going to be looking at another draft. More deletions. Can you make your statements more concise? Again, keep in mind you're operating within page limits. Almost a lot of the time you are operating within a page limit under the local rules. But also, just to keep the court on task, is it concise? If I read it, do I understand it? And that kind of goes to the last slide when you're reading for relevance. If it doesn't go to your ultimate request or you don't tie it into something later, it's probably not relevant, right? So you can delete it. And the typical KISS, right? Keep it simple, stupid. Like, just say it plainly. And watch your tone. So you don't want to be defensive. You don't want to be accusatory. You want to avoid words like always, never, every time. Things that are just clearly unlikely to be true, right? Because it does detract from your credibility. And again, this time you're asking, is it necessary? So not even just is it relevant, is it necessary for the court to know that for this? And so now you've gone through your second round of deletions. So what do you do now? This is when you send your first draft and your revised draft to your attorney, and they will work with you to revise and finalize what is ultimately going to be presented to the court. Again, the reason why I say include your word vomit draft is because you might have deleted something that your attorney actually finds significantly important, right? We have a different understanding of what the court is looking at for the law, but we have to rely on you to get the facts. And so you might think that a fact isn't relevant, but it actually goes precisely to a prong of the law that you're asking the court to rule on. And so we need that piece of evidence. And again, compile your exhibits. Tell your attorney, okay, I think this supports this section and this section. And even if you don't use all of them, it is helpful to us to know that there is corroborating evidence, and then it might be helpful on your reply. So let's say, we determine some exhibit just isn't going to carry the day, and because of the page limits, we've deleted it. And while you testified that it exists, we didn't include it. But on response, the opposing party says, well, that's not true, and there's no evidence of it. Well, now I can go back to the documents you sent me, and when we're preparing your reply declaration, we can then attach that exhibit. So it's always better for your attorney to have more information rather than less, because we can go through it later. You never know when it's going to become relevant. Are we done yet? The answer is no. So when your attorney sends it back to you, you need to be meticulous in reviewing your declaration. If there is anything in there that is not accurate, no matter how small an error, you need to alert your attorney to that, because keep in mind, it's considered testimony. You are signing under oath under the penalty of perjury. And not only is perjury a criminal offense, if you're perjured on the stand, you've lost credibility, and the court is much less likely to give you what it is that you are asking for. So you need to be very careful that what you are signing is your understanding of what is actually true. So just keep that in mind. I would read it twice, 3 times. And if you have a question about whether it's an error or whether your attorney maybe misunderstood something, let them know. correct them because it's your name at the bottom of the document at the end of the day. So that is probably my biggest piece of advice. Don't breeze through signing. Don't wait until the last minute to review it. Take time to sit with it and confirm that the information in it is true. So if you have any questions about how to draft a declaration or declarations supporting a specific motion or type of case, we're happy to help at Beresford Booth. This is something that we do almost every day, is reviewing client declarations and declarations from third parties to get the relevant evidence before the court. So give us a call and we'll help you out. Thank you so much, everybody.